And now it's time for another case law update. Today we're taking on DeWolf, Boberg & Associates versus Pethick. It's a case out of the Fifth Circuit Court of Appeals, and it's about trade secret misappropriation. DeWolf is a management consulting firm based in Dallas. They store their information in internal systems such as Salesforce and SharePoint. These databases contain things like meeting notes, internal strategies, and specialized client lists, including a resource they refer to as the DoD list, which targets prospective defense sector clients. In 2018, DeWolf hired Justin Pethick as Regional Vice President of Sales. In 2020, he was recruited by the Randall Powers Company, a firm founded by a former DeWolf employee and considered to be a direct competitor of DeWolf. Pethick accepted the offer while still working at DeWolf. Before officially resigning, he allegedly directed an employee at Powers to contact a DeWolf client. DeWolf found out and promptly cut off his access and later sued both Pethick and the Powers Company. DeWolf alleged misappropriation of trade secrets, saying that Pethick poached 3 potential clients by using internal confidential materials. The district court in Texas granted summary judgment for Pethick and the Powers Company. On appeal, the Fifth Circuit affirmed the decision. To win a trade secret misappropriation claim in Texas, you have to show 3 things. 1, a trade secret existed. 2, the secret was acquired through a breach of confidential relationship or other improper means. And 3, the defendant used the trade secret. Here, the court said DeWolf failed to identify any specific trade secrets. It wasn't enough for them to allege that Pethick had accessed Salesforce, as it contained both public and non-public information. The court needed to know exactly what data, notes, and lists were being claimed as trade secrets. Instead, DeWolf presented the court with many redacted materials without tying specific entries to specific claims. The court said they had no obligation to sift through the record in search of evidence. Second, even assuming a trade secret did exist, DeWolf failed to show any evidence of use. The only real piece of evidence was an email where Pethick requested the DoD list, but forensic analysis showed he never possessed the document at his new job. No other evidence linked the alleged trade secrets to client poaching or commercial gain. So why are we talking about this? Well, these sorts of claims are very common in the energy industry, so I thought it would be a good idea to use this case to highlight some best practices. If you are the original employer, you need to be protecting your trade secrets, which admittedly DeWolf did a good job of in this case. Once an employee leaves, you need to have their computer checked and see what they've been accessing and downloading in the time leading up to their leaving. If you suspect that something was taken, you need to immediately send a cease and desist letter to the new company and ask for proof that nothing of yours is being used at the new company. If you're the employee, don't save personal items to your work computer, and don't download anything around the time you're getting ready to leave. Or get ready to sit down and go through all your personal photos and documents with a forensic team, because they are going to look at all of it. Some people might think this sounds silly, and I don't know exactly what happened in the DeWolf case, but Texas law holds the new company liable for this as well, so there's a good chance that you could get let go by your new company when they get that cease and desist letter, so that they don't get pulled into litigation. And my last advice is to the new company. Have a policy in place that states that employees are not permitted to bring any information, confidential or otherwise, from their old employers without express permission. You are hiring these people for their skills, not for trade secrets. And if you get one of these cease and desist letters, respond immediately. Often these things can be resolved with a voluntary third-party sweep of your systems. Okay, I'm off my soapbox. I hope you learned something today. Thanks for listening. I'd like to give a shout out to Kanika Draksharam, a law clerk at our Houston office, for her help on this update.